Hi everyone, welcome back to federal government. This is our latest topic, which is the judicial branch. So today we're going to start off by seeing a picture of the Supreme Court, which is located in Washington, D.C. There are certain questions that you should know just as general knowledge. The first one is, who was the first female justice on the United States Supreme Court? Secondly, why are lifetime tenures and why can pay not be reduced for judicial members, meaning the judges? Why is that the way it is? As you will hear further on, judicial members, the justices at the Supreme Court and at the federal level, have lifetime tenure, meaning they will sit on the bench that they have been appointed to until they resign, retire, or die. Also, their pay cannot be reduced. Why would that be important? And keep these questions in mind so that if you have any further questions or as we go along in this lecture, you think of something, feel free to email me later on and ask questions or ask for clarification. But those are two important things to keep in mind when we are talking about justices. Now to start off with, the legal system. What does the legal system do? Well, very simply put, the legal system settles disputes. Well, how do courts decide cases? Courts decide cases by hearing the facts on both sides of a dispute and applying the relevant law or principle to the facts. Courts have authority over the citizens and the government. Courts are obliged to maintain neutrality and impartiality in deciding disputes. The essence of the rule of law is that government officials are judged by the same laws as the citizens. Now, these court cases that we speak of, these court cases can proceed under a criminal or a civil law. American court cases, these are the two choices we have, criminal or civil. Now, criminal law, this is the law branch that defines crimes and provides punishment for criminal acts. It deals with cases in which the government is charging an individual with violating a statute that has been enacted to protect health, safety, morals, or welfare of the citizens. In criminal cases, the government is always the plaintiff, meaning the party which brings a complaint to the court. And the plaintiff is the one that alleges that a criminal violation has been committed by a named defendant, the defendant being the one against whom a complaint is brought in a criminal or civil case. Now, punishment for these cases involves fines and sometimes imprisonment. Now, the second type of law is civil law. Civil cases involve disputes among individuals, groups, corporations, and other private entities, or between such litigants, meaning those previous parties, and the government. So the government can be a party in both criminal and civil law. Punishment for civil cases may require monetary or punitive payments. These civil cases also involve plaintiffs and defendants. In deciding these cases, courts apply statutes or laws and legal precedents. Legal precedents are those prior cases whose principles and decisions are used by judges as the basis for their decisions in present or future cases. Now, such precedents are applied under the doctrine of stare decisis. This means letting the decision stand. The doctrine that a previous decision by a court applies as a precedent in similar cases until the decision is overruled by a higher court. So this means that when we talk about precedents, we are talking about prior cases that have already been decided. And so we are using what we learned in those prior cases in current cases because they have similar circumstances or they deal with the similar or the same statutes. And it is something for the judges to use as a basis for judgments, for current judgments. Now, just so that you know, a Supreme Court, because eventually we will be talking about Supreme Court here as the ultimate judicial member. It is the highest court in the land. All Supreme Courts, the Supreme Court is known by the last name of the Chief Justice. The current Chief Justice is John Roberts. So any decisions that come from the Supreme Court while John Roberts is the Chief Justice, they will be known as decisions from the Roberts Court. Now we speak of these things such as the name of the courts or what the opinions are called because these are opinions that will move forward to settle disputes. Anything that comes out of the Supreme Court is the law of the land. And to get to the Supreme Court, we have to go through the initial trial, an appellate system, and then the Supreme Court. So, speaking of which, we have our courts. These are the courts. The trial court, which is the original court that hears the case to begin with. The trial court is the one with original jurisdiction. The appellate courts are the courts that will hear any appeals from the trial court, and ultimately, of course, is the Supreme Court. The Supreme Court is your last court. It is the court that will issue, if they so choose to hear a case, what becomes the law of the land. So the system of courts have been established by both the federal and state government, and both systems have several levels. Of course, the state trial court is the first court to hear a criminal or civil case. This is done in front of a judge and sometimes a jury. If convicted, the defendant may appeal to a higher court, such as the State Court of Appeals. And this is the court that hears the appeals of trial court decisions. And from there to a state Supreme Court, which is the highest court in each state, which primarily serves an appellate function or something similar to the federal Supreme Court. Most cases, both civil and criminal, are settled before a trial with a plea bargain. A plea bargain is a negotiated agreement between the parties. In criminal cases, a defendant agrees to plead guilty in return for the state's agreement to reduce the severity of the criminal charge the defendant is facing. Considerable similarities are found from state to state in their laws when it comes to not just the levels of the courts, but also to the ability to plea bargain. In the case of contract law or civil law, most states have adopted the Uniform Commercial Code. This is a code used in the area of contract law to reduce interstate differences in judicial decisions. So cases are heard in the federal courts if they involve federal laws, treaties with other nations, or the Constitution. But when it comes to commercial matters, most states will have this Uniform Commercial Code so that each state has similar abilities to hear cases. Now, when it comes to the jurisdiction of the Supreme Court, I have spoken about the Supreme Court here just a moment ago, about how it is the ultimate appellate court. However, the Supreme Court does have original jurisdiction. The original jurisdiction of the Supreme Court is that it is the court that will hear cases involving foreign ambassadors and issues in which a state is one of the parties involved. It is defined as the authority to initially consider a case. That is what original jurisdiction is. The authority to initially consider a case. Now, appellate jurisdiction. Appellate jurisdiction is the authority to hear appeals from a lower court's decision. So the Supreme Court actually has both original and appellate jurisdiction. Now, the Supreme Court has appellate jurisdiction in all federal cases and in cases originating in state courts. Civil and criminal cases can be appealed in federal courts when they raise federal issues. For example, an appellant, the person asking for an appeal, may assert that their due process of law, the right of every citizen against arbitrary action by a national or state government, was denied. In addition, in criminal cases, defendants convicted by a state court may request a writ of habeas corpus, which is a court order to the authorities to release a prisoner deemed to be held in violation of his or her legal rights from a federal court. Now, the federal courts. The federal courts actually only hear a very small percentage of all cases. Although the federal courts hear only this small percentage, their decisions are of critical importance for American society as a whole. Of the cases reviewed by the Supreme Court, usually it is only a minimal percentage that are argued before the court and heard by all 9 justices. And this is because the court has the power to decide what cases it will hear, and it generally deals only with matters of national importance. Now, the lower federal courts. The lower federal courts are the ones that handle most cases. The lower federal courts are the U.S. District Courts. Now, these courts are courts of original jurisdiction that are responsible for, of course, discovering the facts in a controversy and creating the record on which just judgment is going to be based. Now, the appellate courts. The appellate courts hear 10% of the lower courts' cases. This is because in courts which have appellate jurisdictions, judges receive cases after the factual record is established. So there are no new facts that can be presented before appellate courts. So therefore, it is a very small number of cases that actually make it to the appeals courts. Of course, the Supreme Court is the court of final review. This is the United States' highest court. Article 3 of the Constitution vests, meaning gives, the judicial power of the United States to the Supreme Court. The Supreme Court is made up of a Chief Justice, and the Supreme Court, the justice is the one who presides over the court's public session. So the court is made up of 1 Chief Justice and 8 associate justices for a total of 9 judges. Congress, of course, has the authority to change the size of the Supreme Court. The Supreme Court is the only federal court established by the Constitution. All of the lower federal courts are created by statute, and can be reconstructed or presumably even abolished by Congress. Now, the judges. The judges are appointed by the President and confirmed by the Senate. This is the process by which all federal judges, note that I say all federal judges, are appointed by the President and confirmed by the Senate. Now, the Solicitor General. The Solicitor General is the top government lawyer in all cases before the Supreme Court. It is the Solicitor General whose job it is to defend the U.S. government or to prosecute for the U.S. government. So it is their job to represent the government. Now, there is one type of brief that I need y'all to know about, and that is called an amicus curiae brief. Amicus is spelled A-M-I-C-U-S. Curiae is C-U-R-I-A-E. You will hear about amicus curiae briefs when there is a case before the Supreme Court. And what this brief does is it is a friend of the court brief. Individuals or groups who are not parties to a lawsuit that is being heard in the Supreme Court can ask the Supreme Court or can tell the Supreme Court that they are in favor of a position that they are hearing in the court. So they are helping the court by presenting these friendly briefs that are offering support for whatever the case is that may be before them. They are called, once again, amicus curiae briefs. They are called friend of the court briefs. Now, power. The power of the Supreme Court is judicial review. So what exactly is judicial review? Well, this power of judicial review is very important. It is the power of the court to examine and, if necessary, invalidate or declare unconstitutional acts undertaken by the legislative and executive branches. So all judicial review means is that the Supreme Court has the power to examine and, if it so finds, invalidate or declare unconstitutional acts or laws that have been undertaken by the legislative and executive branches. Now, moving forward, judicial review of acts of Congress. The Constitution itself does not give the Supreme Court power of judicial congressional review. The Supreme Court asserted this power under Chief Justice John Marshall in a case called Marbury versus Madison. This is where the Supreme Court started using judicial review, was because of this case of Marbury versus Madison. Since that time, the Supreme Court has struck down only 160 congressional acts. In this day and age, judicial power has come to be accepted as natural, if not necessarily intended. Now, judicial review also applies to state actions. The Constitution does not explicitly grant the court, meaning the Supreme Court, the power of judicial review at the national level. So why would it be able to be applied at the state level? Well, the logic of the Supremacy Clause, Article 6, is very strong. It states that laws passed by the national government and all treaties are the supreme law of the land and superior to all laws adopted by any state or any subdivision. Also, the Judiciary Act of 1789 conferred upon the Supreme Court the power to reverse state laws and constitutions whenever they conflict with the U.S. Constitution. That brings us to our next question. What are judicial decisions based on? Many of the court's decisions are based upon statute application, meaning what the justices infer the law to mean. However, over time, judges have developed a body of principles called common law. Common law is simply based on the precedent set by previous cases. The written opinion of an appellate court is halfway between common law and statutory law. It is made by a judge and draws heavily on the precedent of previous cases. Much civil law has been constructed by judicial messages to other judges, which may eventually turn into legislative enactments. The courts themselves cannot directly change the behavior of citizens or the government. However, they can make it easier for a mistreated person to gain some sort of compensation. Now the Supreme Court, specifically. Most cases reach the Supreme Court by appeal, meaning there are not many cases of original jurisdiction that are filed at the Supreme Court. Most cases that go before the Supreme Court are appeals. Now, the Supreme Court controls the number of cases it reviews. It does, of course, review cases under its original jurisdiction, which includes cases between the United States and one of the 50 states, cases between two or more states, cases involving ambassadors or other ministers, and cases brought by one state against citizens of another state or against a foreign country. Writs. Now, most cases reach the Supreme Court by a writ of certiorari, and that is spelled C-E-R-T-I-A-R-A-R-I, a writ of certiorari. What that is a decision by at least, and that is with a decision by at least 4 of the 9 justices to review a lower court's decision. Certiorari means to make more certain. So out of the 9 justices that sit on the Supreme Court, 4 of them have to decide to hear a case. That case is brought to them via a writ of certiorari, which means the Supreme Court is charged with making that decision from the lower court more certain. The Supreme Court will receive an order or will issue an order to deliver the records of a particular case to be reviewed for legal errors. So with the writ of this writ of certification, which is another manner in which the Supreme Court receives cases, is a writ of certification. It can be used when a U.S. Court of Appeals asks the Supreme Court for instructions on a point of law that has never been decided. A second alternative avenue is the writ of appeal. This is used to appeal the decision of a 3-judge district court. About 1% of all cases seeking Supreme Court review will be heard by the court, which is a very, very small number of cases when you consider how many lawsuits are out there being handled on a daily basis. Of course, since it is the Supreme Court that we are talking about, there is always going to be lobbying for access before the court. And this lobbying comes from not just special interests, but from other courts also. Interest groups, societal forces, they're all going to use several strategies to persuade justices to listen to their problems. This is why you always see people protesting, people demonstrating, people out in front of the steps of the Supreme Court trying to get on the news media, and now with the age of social media, on every social media platform, so that their voices can be heard, and hoping that somewhere along the way the justices will hear their concerns. Now, the pathway to the Supreme Court is very lengthy. Once a case is accepted by the Supreme Court, the process to actually be heard and to get to the appeal is very long. Attorneys on both sides of the matter have to prepare briefs. The briefs are written documents in which attorneys explain using case precedents, using previously decided cases. They are trying to tell the court, the Supreme Court, why they should find in favor of their client or their side. This is when sympathetic interest groups or individuals will file those amicus curiae briefs that support the claims of one or the other side. Once briefs are submitted, you have oral arguments. Now, these oral arguments occur under a strict time limit for both attorneys on either side of the matter. They have to appear before the court to present their positions and answer questions that will be posed by the justices. Once oral arguments have taken place, there is conferencing. After these arguments, the court, the justices themselves, will meet to discuss the case. The discussions are kept secret and a decision is reached on a majority basis vote. During the conference, justices can attempt to sway the vote of their fellow justices to their belief. Finally, there is the opinion writing. This is the decision of the court. After a decision has been reached, one of the members of the majority is assigned to write the opinion. The opinion is the written explanation of the Supreme Court's decision in a particular case. Opinions are most important because this opinion that they will write will set precedent for future cases. Once a majority opinion is drafted, it is circulated to the other justices. Majority members who wish to emphasize a rationale may draft what is called a concurrence. In other instances, justices may draft who disagree with the rationale presented by the majority opinion can also write a concurrence, but it would be considered a special concurrence. Now, a different type of opinion is the dissent. Justices who disagree with the majority decision may choose to publicize the character of the disagreement in the form of a dissenting opinion. The dissenting opinion is a decision written by the justice in the minority of this particular case because the justice wishes to express his or her reasoning in the case. Please make note, there can be multiple concurring opinions, multiple dissenting opinions. but there can be only one majority opinion. Now, influencing decisions. What can influence a decision? What can influence a Chief Justice or any of the Associate Justices? Now, the Supreme Court explains its decisions in terms of law and precedent. Court justices may make a decision based on judicial philosophies. This is how justices are influenced. The first one is judicial restraint. Judicial restraint is adherents, the people who are known as having judicial restraint are those justices that will refuse to go beyond the clear words of the Constitution in interpreting its meaning. Justices that practice judicial restraint are true to the letter of the law. Judicial activism. Justices who practice this philosophy claim that the court should go beyond the words of the Constitution or a statute to consider the broader societal implications of its decisions. How will my decision affect the nation as a whole? Remember, the Supreme Court, once they rule, it is the law of the land. It is not just about the two parties that are before them. It becomes law for everyone. So the justices that practice judicial activism are thinking about not just the law itself, what does it say, what does it mean, but how will it affect everybody in the United States. Political ideology. This is the second component of judicial philosophy, is political ideology. Is or are the justices liberal or conservative? What are their attitudes? It is their attitudes that are going to play an important role in their decisions. And lastly, of course, the justices still have an unpredictable manner. There is this element of unpredictability in the appointment process because it is difficult to know how a court nominee will actually vote in the wide range of cases that the courts consider. And because the justices are protected by lifetime tenure, each justice is free to follow his or her conscience and interpret the law accordingly without really having any kind of favor to repay to the president that appointed them. These justices will outlive the presidents. Not just figuratively, but literally. The justices will keep serving long after the president has left office. And of course, the entire purpose of the judicial process was designed to protect liberty. In the original concept of the framers, the constitutional framers, the judiciary was to be the institution that would protect individual liberty from the government. Today, Americans of all political persuasion seem to view the courts as useful instruments through which to pursue their goals, rather than simply protectors of individual rights. So the courts are used as instruments of societal policy. If the courts are treated as simply one more set of policy-making institutions, then who is left to protect the liberty of individuals? It is a question that we should consider and think about. So if you have any questions or you would like to discuss this further, please send me an email and we can discuss how the courts affect you and everyone else. Until next time, y'all stay safe and I will talk to y'all later.